this process of impeachment or removal comes from British practice, and then it was replicated in the States. And the idea was that ministerial officers, executive and judicial officers, ought to be removable via a quasi-criminal process in a legislative body, right? And so in the States, you had this process, this impeachment process, and it could actually be used to impose criminal punishment. When you get to the Constitutional Convention, they want to replicate it, but they want to limit it to just removal from office and barring the person from serving again. And so the president, along with all civil officers of the United States, including federal judges, is subject to impeachment and removal for treason, bribery, or other high crimes and misdemeanors. And the process is the House impeaches or indicts the president. And then the Senate conducts a trial where they decide whether the president is guilty of a high crime or misdemeanor. And then if the president or other people are guilty, they remove the person and possibly impose a lifetime ban. And so the president was made subject to this just like every other civil officer. And the thought was this, among other things, makes the president a responsible executive, not someone above the law. In Great Britain, it was thought that the crown could do no wrong, which was sort of a legal fiction. They said the crown could do no wrong because there was no means of holding the crown legally responsible. And they didn't want to replicate that. And of course, they had an example of responsible executives in the States, and those executives were subject to impeachment, and so it seemed natural that the president would be as well. The only difference is that the Chief Justice sits as the president of the Senate when the president's on trial, rather than the vice president sitting as president of the Senate during that trial.